start by stating that there, from my count, starting from constitutional petition number 16 of 2013, Moses Mnyendo and 908 others versus the Attorney General and another, there are more than 103 judgments from the court system in Kenya on public participation, including decisions of the Supreme Court and Court of Appeal, which are binding to this court. There are decisions of this court and also of other courts on public participation. So it's not a novel question. You cannot state that there are substantial questions of law on public participation because the jurisprudence, the scope, the mechanics on public participation has already been determined. On the second coin to that issue, this petition and the application before you sought to stop a public participation which the National Assembly had conducted or intended to conduct. That public participation has now been completed, and there's a report which has been filed before this court for the court to consider. So what remains as we speak is the application of the law on public participation, which this court can do. Only one single judge can apply the jurisprudence on public participation. My Lord, allow me to make a slight admission that indeed there is only one substantial question of law. My Lord, only one substantial question of law. My Lord, what is the substantial question of law which I see in these pleadings? My Lord, I see it in the context of a substantial question of law which has not matured. They are scratching it, but it is there. They are scratching it. It can only mature after the Senate has considered the motion that was approved by the National Assembly yesterday for the impeachment of Deputy President of the Republic of Kenya. My Lord, that question, substantial question of law, concerns your jurisdiction within the meaning of the provisions of Article 165, paragraph 3C, which excludes the High Court. Excludes the High Court, it dismembers the High Court, denies the High Court jurisdiction to determine the question of removal of President and Deputy President by way of a tribunal under Article 144 of the Constitution. And therefore, by constitutional interpretation, because the Constitution is read conjunctively, not disjunctively, then one can say that a substantial question of law arises on whether the High Court has jurisdiction to determine the removal of a Deputy President by way of impeachment. But my Lord, why I'm saying that question is premature is that it can only be determined after the impeachment proceedings have been concluded at the Senate. Then that question will be ripe, spropped up for determination by this court after hearing both parties. The second point which I wanted to clarify, Mr. Ongoya appears to request that at this stage of the proceedings, you grant some conservatory orders. That you grant some conservatory orders whose effect is to stop the proceedings which are ongoing in the legislative arm of government, that is the Senate. My Lord, one, allow me to emphasize a point. But my Lord, this matter was before you today for directions on the way forward. While on the floor, counsel for the petitioners raised a question in an address in court, questions which he thought are substantial questions of law. And he outlined them for the courts to consider. But my Lord, public policy, which determines Kenya's judicial policy on the consistency on judicial decision-making is very, very important at this stage, because it affects the sequencing of this request which is before court and the grant of conservatory orders. My Lord, the public policy, and today, my Lord, I appeared before your colleague, Justice Mwita, in three other related matters. And directions were given in those other matters, my Lord. My Lord, the National Assembly is a respondent in those matters. So, my Lord, in accordance with the Mutunga rules, there is need in applying the provisions of Section 6 of the High Court Organization and Administration Act, first of all, to put our house in order. So I support that submission that let all these files be taken by the to the principal judge. My Lord, you have no jurisdiction or powers to recall this file from your brother judges. You cannot recall. You cannot issue an order here. But the principal judge of the High Court has jurisdiction to recall these files for purpose of giving effect to that broad public policy of consistency in judicial decision-making. Because right now, my Lord, there's a